Mr. Chief Justice, and may it please the court, my name is Arthur Cooper, and I am here to demonstrate that Hugh Boyd's verbal abuse of Tin 1 does constitute bullying under the California state law. My co-counsel Janice Boone will demonstrate that Hugh Boyd's speech is not protected by the First Amendment. My co-counsel Andie Romero will demonstrate that Sequester School District should be held financially liable for the damages suffered by Tin 1. And my final co-counsel, Edward Rickford, will rebut the respondent's argument. According to section 48900, subsection 1 of the California Education Statute, bullying is defined as any severe or pervasive physical or verbal act or conduct, including communications made in writing or by means of an electronic act. Although Hugh Boyd's individual actions are not severe, the totality of his actions, the teasing Tin 1 after school, posting stereotypical and racist drawings, and using Facebook and cell phones to constantly embarrass Tin 1 is severe. To be pervasive is to be omnipresent. Hugh Boyd, through his use of the internet, cell phones, and drawings, invaded Tin 1's personal, social, and academic life.
What's the difference between teasing and bullying?
According to the California Educational Statute, bullying is severe or pervasive, whereas teasing is more lighthearted, not as serious or hurtful. Through the cartoonish drawings, which were most likely posted inside the school, and subsequent cell phone messages, Hugh Boyd's bullying pervaded Tin 1's academic environment. Through the Facebook page, Hugh Boyd's bullying invaded a primary social media site. And through the teasing after school, Hugh Boyd's bullying consumed Tin 1's mental health. According to subsection 3 of the California Education Statute, a reasonable pupil exercises average care, skill, and judgment for a pupil of his or her age. Tin's actions may seem rash, but they are reasonable for a pupil of his age. In middle school, children can be expected to have a lesser level of maturity and therefore a lesser quality in judgment and decision-making. A young student who may be more susceptible to pervasive and relentless bullying may have seen few ways to escape Hugh Boyd's bullying.
Well, counsel, is the question whether a reasonable student would have reacted the way your client did, or is it whether a reasonable student would have felt embarrassed? Whether it's the reasonable feelings or the reasonable actions.
Could you rephrase the question, Your Honor?
We say it's a reasonable student standard. Is the question really whether a reasonable student would have attempted suicide, or is it whether a reasonable student would have felt embarrassed?
The question is whether Your Honor, the question is whether Tin 1, as a reasonable student, would have felt embarrassed, and as much so as to see that the only option was suicide. Were Hugh Boyd's actions enough and pervasive and relentless enough to push him as far as to commit suicide? And in the totality of his conduct, they were severe and pervasive enough to do so. Despite Tin 1's expected lack of maturity, Tin 1 took the initiative in going to the school principal, Headley Thick, and explaining his situation and the detrimental effect the bullying was having on his academic performance. However, after several unproductive conversations, and with the continuation of the bullying, Tin 1 decided that he had no other option than suicide. On the basis of the evidence provided, I urge the court to overturn the appellate court's decision and to determine that Hugh Boyd's conduct does not constitute bullying. Thank you, and now my co-counsel Janice Boone will address the First Amendment issue.
Counsel, I have one question before you finish. Underneath the bullying statute that you cited, you have to have a reasonable response in terms of either a fear put in that pupil, the reasonable pupil standard, or have an effect of a physical or mental health condition, or experience some interference with academic performance. What category do you believe your client fell under to suscept him to the bullying standard?
As a reasonable people, I feel that Tin Wan was placed under I gotta look at the statute. Mainly causing a reasonable pupil to experience substantial interference, subsection D, with his or her ability to participate in or benefit from school activities, which through the bullying, Tin Wan felt that he had no other choice other than to skip school to avoid this bullying, and therefore experience that substantial interference.
Mr. Chief Justice, and may it please the court, my name is Janice Jones, and I'm here to demonstrate that Hugh Boy's hate speech is not protected by the First Amendment and thus should have been stopped by the school. The First Amendment provisions for basic civil liberties such as free speech, but that does not translate into an absolute guarantee without limitations, such as in cases of harassment or defamation. And furthermore, the court has held in Hazelwood that the First Amendment rights of students are not automatically coextensive with the rights of adults and allows for the censorship of speech in order to preserve the basic educational mission of the school. And thus, in our case, Hugh Boy's hate speech was not protected, and the school absolutely had the right to stop it. The first incident of bullying occurred at a location not directly on the campus, but at a tutoring site near the school. But it was a school-sanctioned project, with the teacher that was in charge receiving a school award for outstanding teacher, and the principal was even associated with leading the project in the local newspaper, and where the parents publicly thanked him, and thus shows that the tutoring received the imprimatur of White's Junior High. And following the standard in the Safe Place to Learn Act, the principal not only has the duty, but the duty to stop boys' speech to protect Tin Wan. Furthermore, boys' bullying didn't end there, but extended to the internet. Hugh Boy, like JS of the Snyder case, created a debasing Facebook page to attack another individual off campus. Though our facts didn't clarify if it was on or off campus. If it was on campus, then boys' speech is certainly subject to school censorship and discipline. And even if it was off campus, it would align with the Snyder case, where the court empowers the school to punish JS's speech, and that her protected First Amendment free speech rights ended when her actions threatened to cause a substantial disruption. And Boy's actions thus caused a direct disruption on campus when other students began mocking Wan with attention he didn't want, and it rose to such a commotion that even the principal became aware. And thus, his harassment damaged the school's overall learning environment, and it would only be proper for the school to stop Boy's hate speech. And even in the Kowalski versus Berkeley County case, the court holds that the Constitution is not written to hinder school administrators' efforts to address hate speech and cyberbullying issues. The circumstances in Kowalski parallel our facts. Both creators of bullying pages reasonably expected that their off-campus conduct would reach the school and create a substantial disruption. And the court in Kowalski affirmed the school's right to censor and discipline school-related speech even if it occurs off campus or it originates outside the school gates, because there's a sufficient nexus between the conduct and the disruption caused on campus.
Pardon me, Ms. Poole. The poster that was put up in the school, is that protected by the Fifth Amendment?
The poster that was posted on the school is characterized as bullying and thus is not protected, as it disturbs the school environment and causes a disruption.
Is it protected by any special rules?
It should not be protected because, as stated in the Hazelwood case, the expression rights of students may be censored to protect the basic educational mission of the school. And especially in the Tinker case, the standard of disruption has been well established, as long as there's a sufficient nexus between students' offensive speech and a disruption of school learning environment. The school has the right to censor the student, and in this regard, our case aligns with Snyder and Kowalski.
Counsel, can you be more specific about how the disruption was caused at the school? I mean, all you've cited thus far is people calling them names. Can you tell me how it was substantially interfered with?
Your Honor, when Boy's hate speech towards Tin Wan
He rallied up his friends to tease Tinwan. It created a commotion at school, created disruption. The students were distracted from learning, and even the principal had to interfere in this, step in this commotion, which showed that it disrupted the school learning environment. And this case is unlike Layshaw, since the courts held that Justin was wrongfully suspended for the content of the speech, but not for its conduct. And thus our case is far distinguished from Layshaw, since it did create a direct, profound effect on the educational environment and even pushed Juan to the point of attempting suicide. And thus, because of Hugh Boy's hateful speech towards Tim Juan and how it led to a direct disruption on campus, I urge the court to see that Hugh Boy's speech is not protected by the First Amendment, and the school is empowered to stop the speech. And now my co-counsel, Andie Romero, will discuss the issue of negligence.
Mr. Chief Justice, may it please the court, my name is Andie Romero, and I will demonstrate that Sequester School District should be held financially liable for the damages that the trial court determined were the direct result of the principal's negligence to the issue. I will demonstrate that 1, the respondent owed a duty of care to Tin Juan, and 2, there is a causal linkage between the respondent's tortious inaction and Tin Juan's emotional distress. As my co-counsels have demonstrated, the California Educational Code provides that each education agency have not only a policy that prohibits bullying, but a program that investigates violations of these standards. The intentions of these standards were not made in hopes that its personnel and its pupils would willingly comply, but clearly dictates that California's school district's orbit of duty is one that is inherently extended in order to efficiently investigate and actively prevent damages to its students whom they are liable for protecting, such as Tin Juan. The facts show that while the principal was fully knowledgeable of Tin Juan's distress from the bullying, he chose not to comply with California law. As reasonably foreseeable, the principal's negligence and abandoning of his duty caused a severe disruption to Tin Juan's inalienable right to a safe, secure, and peaceful school environment.
Well, counsel, is it the case that the principal did absolutely nothing?
Your Honor, the facts show that he did what he could without infringing on the right of Hugh Boy's speech. That because Hugh Boy's speech was not protected, he could have done more to efficiently prevent these damages incurred by Tin Juan. Furthermore, regarding this foreseeability, case law established in the courts in Paul's Graf, Dillon, and Stolzen hold that foreseeability of risk defines the duty to be obeyed. Because liability of tort stems directly from sufficient foreseeability of risk and the determining the degree of the respondent's foreseeability, the courts must first establish guidelines similar to those made in Dillon. The courts must first consider 1, the relationship between Mr. Thick and Tin Juan, and 2, if a reasonable person, not necessarily Mr. Thick in his shoes, but a reasonable person in his place, under those very same circumstances, would have foreseen a risk of danger.
And according to the fact pattern, the principal thought originally that this was not was sort of a compliment. Is that a reason he shouldn't have thought it was a compliment?
Your Honor, as my co-counsels have demonstrated, these were not. Hugh Boy's was very his bullying, was invasive. It wasn't just teasing, Your Honor. It was bullying, and the fact that Mr. Thick has a duty to protect students such as Tin Juan to have a safe, secure, peaceful environment, that his negligence would have his negligence infringed his right to this peaceful. Yes, Your Honor. Going on this foreseeability, Your Honor, if we compare the cases and case law established in Dillon, we find that it was reasonably foreseeable that a driver would have foreseen that this child's mother would have been in that very zone of danger and would have had that emotional distress seeing her daughter killed in that very instant moment. Your Honor, this is just like Dillon in that there is glaring proof that a reasonable person is in his
but does it matter when the principal would have foreseen the risk? I mean, I can see why the principal would foresee the risk after Tin-Wan had approached him and said, this bothers me. But before that, could the principal have foreseen that this would be, could have foreseen that Tin-Wan would have reacted in this way?
Your Honor, are you asking, excuse me, I just need some clarification on your question. This is disregarding whether he met with him, so before he, so considering the fact that there's posters posted on
Right.
school. So considering that he should have still been suspicious, even if he didn't have those posters or the two meetings that he had with Tin-Wan.
And he should have been then doubly suspicious once Tin-Wan came and
Yes, Your
said
Honor,
something to him.
there's so many signs that Mr. Thick chose to neglect. The fact that he was already stressed, emotionally distressed by his parents, that there's posters on school that if we're going to consider these two meetings that he had, it was not just one, it was two. He was a very knowledgeable principal, but still chose to neglect his duty and neglect such a pressing issue to a student who was calling out for help. In comparison with Stolzen, Your Honor, regarding causation, in Stolzen, the courts found that the facts of that case was very ambiguous. Your Honor, as I said earlier, the facts of this case is glaring at us. This facts show that there are so many signs that any more negligence would have pushed a student like Tin-Wan over the edge, even to the fact that he attempted suicide. Your Honor, the respondents may argue that these circumstances would have constituted or would have suspectfully maybe that these are other factors, that these are causal linkage, that his negligence isn't proximate but maybe incremental. Your Honor, if we were to consider the eggshell skull that the court has upheld in many cases, the eggshell skull standard that says that you take the plaintiff as you find him. If we were to take the Tin-Wan as we find him, as I have said earlier, that he was already emotionally distressed, that he was failing in his classes. Your Honor, Principal Thick has a duty not only to protect his safe, secure, and peaceful school environment, but to encourage students to indulge in their educational opportunities. Your Honor, the principal saw that his reaction caused Tin-Wan to miss school, and that he was emotionally distressed, which also contributes to his a disruption to his school learning environment. Your Honor, in conclusion, we find that you find in favor of the appellants. Thank you.
Thank you. We're now in rebuttal. We'll hear first from appellant.
Mr. Chief Justice, and may it please the court, my name is Edward Bickford, and I'm here to show the weaknesses in the respondent's argument that were particularly notable in the interpretations of the anti-bullying statute, the Paulsgraf case, and the Tinker case. The appellant feels that key-boy speech does not constitute bullying, but the evidence shows otherwise. The appellant did make mention of the anti-bullying statute, but placed little attention upon the fact that any student that is subjected to physical or emotional harm is to be considered a victim of bullying. Tin-Wan undoubtedly went through such emotional harm. He was pushed to the point of suicide, and it seems hard to argue that a boy who attempted suicide was not undergoing some kind of emotional duress. The appellant argued that Mr. Wan did not meet the criteria for a reasonable pupil, but it seems pretty reasonable to me that a pupil who is being bullied would go to parental authorities in order to make the bullying stop. And that is exactly what Tin-Wan did. He repeatedly went to Principal Thick on account of the bullying he was facing on an almost regular occurrence. And yet, Principal Thick did nothing to make the bullying stop.
Well, I think respondent has argued that during these meetings, although they occurred, appellant didn't specifically complain about the bullying during those meetings. Is that the case?
Your Honor, the evidence is particularly ambiguous in this case, but it does show that when Tin Wan went to the principal, he did complain that his truancy was being caused by Hugh Boy. Issues been brought up with the posters put around the school, which the principal did take down. If the principal felt that such racist speech really was protected, he would not have taken down the posters. But he did. He felt that certain speech could be restricted, and this certain speech was any speech that was racist or bullying. Hugh Boy's speech undoubtedly meets the criteria for both of these. It is hard to argue that the principal believed that calling Mr. Wan King of Einstein was a compliment, when the lower courts ruled that such an opinion was false. The appellant believes that there was a lack of foreseeability in this case, but the argument is deeply flawed. Students who were bullied often take drastic action. There are countless examples of this in the media. Just recently, a student was recently attempted suicide, and the reason the media found to be was because of bullying. Sure, Mr. Wan can be considered an eggshell skull case, but that does not make him any less legally protected. The law applies to everyone, and Mr. Wan should not be an exception to this rule. The appellant argued that kids will be kids, so their speech should be censored, but failed to mention that the courts has found that speech by students can be censored. The courts did just this in the J.S. Snyder versus Blue Mountain case. The courts felt that the speech that the students partook in was just too damaging and too harmful to be allowed to happen. Therefore, the principal was in the right to not only censor the student's speech, but to punish the students for their speech.
Counsel, isn't that case still under review?
Your Honor, I'm glad you made that point, but that is not the only court case in which the courts have decided that freedom of speech is not always protected out of school. In the Hazelwood case, the courts also decided that the speech that the students were partaking in that case was also not protected. The appellant has tried to dispute the disruptive nature of Hugh Boy's speech, but his speech can be depicted as little else. His speech was so pervasive, so severe, that Mr. Wan actually attempted suicide because of it. As Honorable Chief Justice has already pointed out, a suicide attempt on a middle school campus, might have pointed out that the middle school campus has only 700 students and only 14 Asian students, would undoubtedly be disruptive to the learning environment. The appellant argued that the sequestered school district should not be financially burdened, but let us not forget why the appellant is seeking to financially burden the sequestered school district. They failed to uphold the law. Surely if someone runs afoul of the law, then they should be punished. What good is the law? Those who run afoul of it are not to be punished. In addition to this, the respondent has also argued that the eggshell case should not apply. Your Honor, I see that my time is up. I will sit down.